My dear friends, today I propose a new engagement on media, or I should say international media law. Today in this engagement, we are going to deliberate, rummage different dimensions of media and communication rights under the constitutional law frameworks of Saarc nations. In this particular engagement, I propose to understand and to deliberate media and constitutions, communications rights, idea of communications rights and political ideology, to what extent political ideology has been formulating, shaping different dimensions of media and communication rights, particularly in the context of democracy, pluralism. At the same time, we are also going to rummage the different contours regarding the determination of geopolitical province of media freedom and free speech in South Asia, right to free expression, right to privacy, right to protection against hate and racial speech. Particularly, freedom of press in emerging democracies and what has been the media response to LGBTQI rights in the context of the Saarc jurisdictions or in South Asia. We have to rummage, my dear friends, the safeguards against the abuse of power, constitutional guarantees, prohibitions, and the institutional safeguards on free press and speech. And particularly, we have to take into account what has been the contribution of the institutional architecture and institutional framework, particularly National Commission for Human Rights in South Asia. I am going to deliberate, my dear friends, some of the nuances which have been incorporated in the Code of Criminal Procedure 1898 in the construct of Bangladesh. We should not forget, my dear friends, Official Secret Act of 1923, as it is currently being applied in Bangladesh, Contempt of Court Act 1926, Printing Press and Publication Act 1973, Special Powers Act 1974, Copyright Act 2000, the Information and Communication Technology Act 2006, particularly Section 57, becomes very much relevant in the context of Bangladesh. There is another important piece of legislation which has been recently passed by the Bangladesh Parliament, and that is the Digital Security Act, DSA. In the context of Afghanistan, we have to take into account the various dictum, or I should say dicta, fiats, decrees, which are currently applicable, enforceable in Afghanistan in the absence of a constitution, because currently we do not have any kind of a constitution in Afghanistan, or in other words, and let me put it like this, there is an unwritten constitution in Afghanistan. Though some of the important observations have been made, and there are some, murmuring in the political quarters in the new dispensation in Afghanistan, that there is a possibility to invoke some of the provisions of the 1964 constitution in Afghanistan, though that was a monarchical, constitution, and monarchy has also been recognized in the very what you call, preamble of the 1964 constitution of Afghanistan. In the context of other important jurisdictions like India, since entire South Asia with few aberrations have been the colony of the British Empire, so certain important piece of legislations have been there in the United, South Asia, like Press and Registrations of Books Act, like Vernacular Press Act of 1878, passed by the British Parliament, then the Telegraphic Act of 1885, and the Newspapers Incitement to an Offence Act 1905, Copyright Act of 1911, and Cinematographic Act of 1918, and Indian Press Act of 1910. These were the legislations which have also been, invoked, and some of the provisions with the new what we call incarnation have also been retained in Pakistan, Bangladesh, India, and other important, jurisdictions, including Sri Lanka. So this is how we have to understand the freedom of media in the Saarc what we call, legal frameworks. But at the same time, my dear friends, it is equally important to understand that there are, certain important constitutional provisions which are available in the constitutional scheme of the Saarc, nation states. If you take into account Afghanistan, as I have already submitted that there is no constitution currently in operation in Afghanistan, but if you take into account the suspended what we call, constitution, or abandoned, constitution, or discarded what we call, constitution, whatever may be the nomenclature, Constitution of Afghanistan 2004 contains preamble and Article 34 and Article 50, which empowers freedom of media, which gives or bestow media freedom and other important, rights. In case of, Constitution of Bangladesh, 1972 Constitution, preamble plus Article 39 provides freedom of media. In case of the Constitution of Bhutan of 2008, preamble and Article 7 subclause 5, we are having that there is a media freedom in case of, Bhutan. In case of India, my dear friends, under the Constitution of India of 1950, preamble plus Article 19 of the Constitution of India empowers the media and provides a number of what we call of, liberties and freedoms. Then the Constitution of Maldives, preamble to the Constitution of Maldives, along with Article 24, Article 27, and Article 28. These are the three important articles of the Constitution of Maldives, where we find freedom of media and other important what we call, media rights, or the rights available to media. Then under the Constitution, the new Constitution of Nepal of the 2015, preamble plus Article 17, Article 28, which is relating to right to privacy, is of vital importance in the context of, Nepal. And in case of the Constitution of Pakistan, my dear friends, of 1973, preamble plus we are having Articles 19, 19A, and Article 28, which takes into account the entire architecture or constitutional what we call, framework and constitutional guarantees which are available, and that ensures even the freedom of media. And in case of the Constitution of Sri Lanka, it is the preamble and Article 10 and Article 14 subclause 1A that empowers and ensures freedom of media under the constitutional framework. My dear friends, in this particular, deliberation, we should try to cajole the role of the, constitutions in media matters. And we should try to understand media as his master voice, that is the new incarnation which is being adopted by the media outlets, media establishments, and media houses in various jurisdictions in South Asia. Free press in emerging democracies has been confronting with a lot of challenges. Lot of issues are emerging, and some of the issues are having some kind of a cascading impact beyond the what you call this region. We have to understand, my dear friends, the safeguards against the abuse of power and different constitutional guarantees which provides us some kind of a what we call safety walls and firewalls, and at the same time we should try to understand the prohibitions and the institutional safeguards on free press, particularly role of the institutional frameworks. This is something which is of vital importance, my dear friends. Therefore, when we talk of media freedom, then, my dear friends, media freedom and independence are the pillars, cornerstones of a given democratic society. My dear friends, media makes up the bridge between the political authority and public opinion. So far its independence is concerned, it is crucial for the survival of democracy in any given circumstance. My dear friends, the history of the media has always been paved with the obstacles of the different what you call nature. Freedom and independence of media in the world constitutes the most important critical political economy. And when we take into account the critical political economy of the media, that was used as a theoretical what you call framework for the study of communication rights, constitutional frameworks, and other important dimensions. My dear friends, media makes up one of the most important media institutions in a state of law. And to maintain harmonious relationships between the citizens and the leaders of a given society, media must be free from economic and political interference. However, the relationships between media and the politics often denote either contradictions, paradoxes, conflicts between the two, or more what you call submissions of the media to politics. In a state of law, contradictory conceptions, ideas, issues are key to collective deliberation and discussions. In contrast, an autocratic regime does not allow debates and public discussion when making decisions that concerns its citizens. Despite the endeavors made by human rights organizations and media organizations, media institutions, media associations, the challenge of media independence and freedoms remains a long peregrination. In societies shaped by class struggles, my dear friends, like South Asian societies, the mainstream media make up the voice of the ruling class. Therefore, the link between media groups and the capital endangers and creates a danger to the media's editorial freedom. And this is something we have been witnessing in the context of South Asia. At the same time, alternative media which frequently lack financial resources, fail to survive. In South Asia, where the state is more powerful than the political ruler, freedom and independence of the media institutions are not endangered. But if I put a different kind of a scenario or a contradiction or in contrast, in a country where the ruler is more powerful than the state, the media falls under the control of the political power. Whether regarded as a democratic media agency or as an ideological state architecture, the media has always played an important role in shaping the worldview of a given society. Therefore, my dear friends, the desire for a political ruler to control the media lies in the significance of the media, and this control is often translated into restrictions and censorship, and this is something we have been witnessing in South Asian jurisdictions. That is the situation which is presenting a very murky what we call architecture. Because if you take into account, my dear friends, the relationship between media and politics, that has been an important what we call deliberation in social science, what we call literature, in anthropological studies, because the focus of media and politics has been to analyze the influence of media on politics and how a particular political system affects the ways media what we call operates or function. My dear friends, in the arena of media and politics, known as the political communication, is primarily dominated by a strong empirical traditions in many jurisdictions, including United States of America and many of the European nation states, along with the existence of the qualitative tradition. However, in case of South Asia, the study of the relationship between media and politics has currently been preoccupied by qualitative what we call literature, with a very few quantitative studies available on this particular field. My dear friends, the field of media and politics could best be conceptualized as the study of the relationship between media actors. And who are the media actors? Journalists, media owners, political actors. I mean the candidates and political parties, and the diverse public or the multicultural stakeholders. In South Asian context, my dear friends, it is important to recognize the diversities that inform the relationship of media and politics at various what we call stages, various what we call layers. And that is why I call this relationship a multi-layered what we call relationship. If you rummage these layers, you will find linguistic, ethnic, and regional diversities that are the most what we call prominent ones in the context of South Asia. While taking into account, my dear friends, the existence of the substantial or subnational what we call identities with a particular nation. For example, India has 22 officially recognized languages, even more than that, and newspapers and news what we call televisions are available in almost all the official languages. These diversities make it difficult for the media to have an impact beyond the specific audience. Therefore, it is not easy to study the agenda setting power of the media when audiences are vertically and horizontally, my dear friends, fragmented, truncated, and divided along linguistic lines and exposed to diverse sources of information. Nevertheless, freedom of the press has always been protected legally in majority of the South Asian what we call jurisdictions. Repression and attacks on freedom of what we call speech are regularly what we call reported. The Freedom House report, if you consult this report, particularly the report of the 2021 and report of the what we call 2020, which monitors press freedom globally in addition to people's access to political rights and civil liberties, branded all South Asian what he call jurisdictions in global freedom score as partly free. Significantly, my dear friends, Freedom House report, particularly of 2020, for the first time downgraded a major country in our part of the world, and that is India, from free to partly free on account of growing human rights violations, growing discrimination against what we call minorities, and repression against civil liberties and media freedom. If you take into account these backgrounds and the nuances, then the deliberations upon media and politics in South Asia is marked not only by complexities but also by a lack of scholarship on the subject as compared to other what you call regions of the world. Even within South Asia, my dear friends, most of the deliberations, discourses, literature, scholarships on media and politics deals largely with only one particular jurisdiction, and that jurisdiction is considered to be the most important jurisdiction in South Asia, and that is India. The reason emanates perhaps from the dominant position, from the regnant what we call geostrategic importance of India within the South Asian region, but it could also be attributed to the mostly authoritarian nature of the political system in all South Asian countries in this particular context. So we cannot forget this kind of a what we call analysis, and therefore it becomes important, my dear friends, to understand what exactly has been the constitutional frameworks in South Asia, as I have already submitted the different articles which have been incorporated to understand the idea of what we call of media freedom, fundamental rights, or media freedom as a fundamental human rights under the constitutions of South Asia. If you take into account, my dear friends, the legal framework of the freedom of press in South Asia, that has been in true sense inspired by various international bodies such as the United Nations, US constitutions, and the British Constitution. These what we call constitutions and international treaty bodies and international treaty obligations have impacted our making of the constitution, and these what we call influences are reflected in subsequent what we call enactments passed by respective South Asian parliaments. And I must mention, my dear friends, the Universal Declaration of Human Rights in its charter. Under Article 19 of the Universal Declaration of Human Rights, where we find a clear-cut statement that everyone has the right to freedom of opinion and expression and right to seek and impart information through any medium, regardless of its what we call frontiers. So this is something which is very, very important, and it has become some kind of a what we call a contention, a kind of a bone of gospel gratification, I should say. And with this, there in the constituent assemblies of all the jurisdictions in South Asia, and particularly in India, there happens to be an urge to include freedom of press as a separate article. But the framers of the Indian Constitution were well aware of the fact, my dear friends, that absolute freedom to media may become very disastrous. And it has been what we call pointed out by the chairman of the drafting committee, who was, Dr. B.R. Ambedkar was heading this committee, and he was of the view that the press is merely another way of stating an individual's or citizens what we call rights. The press has no special what we call rights which are not to be given or which are not to be exercised by the citizens in his individual capacity. So that kind of orientation was provided, And therefore it becomes important, my dear friends, to understand what exactly, as I have already pointed out, there were certain important legislations. And in the context of South Asia, my dear friends, media has developed leaps and bounds, but certain times it has struggled to surface and to what you call exercise its freedom. And in that particular what you call context, it is very very difficult to what we call avoid the political impacts and political pressures. But of late, what we have been witnessing, media in South Asia has become complacent, pliant, and docile. So that is my understanding of what we call of the media functioning and media operations in our part of the world, and that is South Asia. Any questions? Any observations? Any comments as of now? Yes. Well, there are number of overarching observations that one might draw from the constitutional scheme which has been adopted collectively as well as individually by the constitution framers in South Asia. We can quickly notice, my dear friends, how the constitutions in South Asia demonstrate the need to move beyond the familiar what we call discourse on regional constitutional rights that particularly tend to pit, my dear friends, certain important what we call value orientation against the value orientation of other what we call regions. If you take into account the Western values, then the Western values have been pit against Asian values in the context of what we call of the media freedom, in the context of what we call of the media freedom as a fundamental right. And in the name of, or in the context of media freedom, we cannot underestimate the importance, significance of communication rights, which have also been guaranteed and which are inherent in the schematization of the constitutional orders in South Asia. So, Western values versus Asian values. Therefore, a distinction which itself attaches to classical distinctions between individualistic and communitarian perspectives on rights. As my dear friends, such a framework does not offer us much to work with when we think about South Asia. And South Asia, a region which features courts robustly committed to judicial review and often skeptical of the political process, but nevertheless proactive of groups and attentive to recognizing and entrenching diverse groups' interests. Therefore, the struggle over how far a nationality liberal constitutional order can accommodate groups' rights is witnessed writ large across South Asia. And when I say writ large across South Asia, I mean that we can see it in the essential practices doctrine and Datic rights in India. As we see it in Pakistan, where judicial review was expanded under the auspices of the Shariat courts. And it is also evident in the certainty in Nepal over whether to extend positive rights to potential national identity groups. Another important direction, another important observation should also be what we call, there. And this second important observation takes into account, my dear friends, the South Asian region. And South Asian region, my dear friends, sees major gaps between constitutional aspirations and the state propensity, or I should say the state capacity. The primary trigger, the primary what we call, driver of constitutional development is frequently or often the brutal reality of the state failure. This is not unique to South Asia alone, my dear friends. But it is hard to imagine a place where the gap between aspiration, I mean the constitutional aspiration, constitutional utopia, I should say, and the capacity is more severe. And this kind of a gap, this kind of a hiatus, this kind of a wedge, linked with the radical pluralism, class division, political instability, and that conveys, my dear friends, that the judges often couple grand what we call, proclamations with dialogic and weak review structures. They are pervasively concerned with sustaining their own power and guarding the conditions of their own legitimacy under these what we call, situations, circumstances, and conditions. And there is more to be what we call, opined, my dear friends, about the political, sociology. That is what we call, underscoring and underlying this legal what we call, state behavior. But it is at work in each of the what we call, constitutions of South Asia. But at the same time, my dear friends, there happens to be some kind of a, inconsistency. Inconsistency in the doctrine exposed by the, constitutions, all the South Asian constitutions, and their attempt at reconciling the common law and the constitutional text may simply be the flip side of this particular what we call, judicial management strategy. My dear friends, what we witness in Pakistan, if you take into account Pakistan, then the Pakistan Supreme Court rights-based jurisprudence gives us a thick what we call, description of the court's self-conception as a political body that must attend to its own what we call, preservation in complicated ways. The study of the religious freedom, if you take into account in the context of, India, then we find very important what we call, reconciliatory tones that has also been what we call, advanced by the Honorable Supreme Court of India. Because religious freedom in India describes a holding pattern through which judges are able to cement and preserve their authority in the management of, contradictions, in the management of paradoxes, particularly of a religious character, and intra-community and extra-community conflict. And finally, my dear friends, if you take into account the constitution of Nepal, then in the context of Nepal, the role that judges play and the psychological burdens that they might carry in countries undergoing constitutional transitions is of vital importance. Therefore, my dear friends, the features of constitutionalism in South Asia that we notice is the centrality of what we call, of a very vast what we call jurisdiction, and that is India, and that we have to contextualize, and at the same time we should also try to assess its what we call, impact upon various, jurisdictions in South Asia. Because what we have been, witnessing of late, that all the constitutions of, South Asia show that all countries adopted an Indian-style public interest litigation model in cases where we find the violations of the communication rights of the citizens of South Asia in their respective jurisdictions. At the same time, how these what we call violations are taking place, then it is the public interest litigation model that has been developed by the Indian jurisprudence or by the highest judicial establishment of India, and that is the Supreme Court of India. But the Supreme Court of India has also emulated some of the important what we call architectural and structural manifestations of this kind of a novelty, which is today known as the judicial activism or the public interest litigation in our part of the world, that has been emanated from the idea of American realism that has been started in United States of America as an affirmative action on the part of what we call of individualism, or on the part of what we call of individual who pleaded, litigated, and pleaded before the Federal Supreme Court of the United States of America. Therefore, my dear friends, the prevalence of the public interest litigation and relaxed standing requirements have had a profound what we call consequences, both for the substantive character of the litigation as well as for the institutional power of the courts and their what we call relationships with other organs of the state in all the South Asian jurisdictions. My dear friends, if you take into account the current scholarship or the existing scholarship that has shown that other Indian what we call public law doctrines, such as the placing of substantive limitations on the constitutional amendment power, have similarly spread across the South Asian region, and this is not the place, my dear friends, to pursue further this kind of a, because I got my own limitations while taking into considerations the limitations which are warranted, and we have to take into account of all the constitutions of this particular region, and therefore it is the what we call reason for India's influence, and that may what we call partly be its political authority within what we call South Asia, but it may also be a function of the similar circumstances, namely the political corruption, widespread illiteracy, and low education levels, coupled with the what we call persons of the civil society activism and non-governmental organizations in South Asia. A further reason for the spread of what we call of the Indian constitutional ideas might also be the perception that the Indian experiment has been a success, to the extent that India remains in whatever what we call imperfections, whatever may be the aberrations, a functional constitutional democracy, and that is the beauty of this kind of a idea when we are talking or taking into account the idea of media freedom in South Asia. But if you take into account the current what we call scenario, you will find, my dear friends, that the picture of media freedom in entire South Asia, including India, is highly flabbergasted, and that needs to be. And any kind of a argument which what we call eulogizes, which what we call showers some kind of a encomiums upon media freedom in South Asia, is nothing but a preposterous argument. So this is how we should try to what we call understand this entire what we call diffusion of constitutional doctrine across South Asia, and that should be what we call critically celebrated by the scholars, and they should come out with more powerful reminder of the vibrancy of comparative constitutional engagement for empowering the level, the current what we call thresholds of media freedom in South Asia. Any questions, my dear friends? Any observations? Any inputs? Would you like to say something? Yes. Mr. Sagar Verma, would you like to say something?
Yes, sir. Good morning.
Good morning, brother.
Yeah. Yes, I agree with you. The situation that you mentioned is true and correct. And yeah,
Yeah. May I get a glass of water? Well, uh, there has been a very, very important case, and it is one of the decision that has been handed down by the Federal Supreme Court of United States of America in 1971, I think. It was New York Times Company versus United States. It was a historical decision, a landmark decision by the United States Supreme Court, particularly on First Amendment of the US Constitution. In this particular decision of New York Times Company versus United States, the Honorable Supreme Court of US stated our government's judges were speaking like this, if I'm not wrong in my recalling, that our government was launched in 1789 with the promulgation of US Constitution, with the adoption of the Bill of Rights, including the First Amendment followed in 1791. And when they were, deciding in 1971, the judges in this particular case of New York Times Company versus United States realized for the first time in the history of more than 180 years since the founding of the Republic or the United States of America, the federal courts are asked to hold that the First Amendment does not mean what it says, but rather means that the government can halt the publication of the current news of vital importance to the people of United States of America. My dear friends, both the history and the language of the First Amendment support this particular view expressed by the judges while speaking through this particular case, and that is New York Times Company versus United States. Press must be left free to publish news, whatever may be the sources, without any kind of censorship, without any kind of injunctions, or without any kind of prior restraints. That was the beauty, and that was the, my dear friends, I mean, the distinction with which this particular case has been identified with. That is the beauty. And that must also be ordained in this particular decision, that the subsequent what we call decisions must also adhere to. That was the novelty. My dear friends, in the very First Amendment, in the First Amendment, the founding fathers of the Constitution of the United States of America gave the free press the protection it must have to fulfill its essential role in the democracy or in the democratic political setup that has been envisioned by the founding fathers in the United States of America. The press was to serve the governed and not the governors. That was the motto. The government's power to censor the press was abolished so that the press would remain forever free to censor government. Press was what he called protected so that it could bear the secrets of governments and inform the people. Only a free press, only an unrestrained press can pragmatically expose the clandestine transactions, deceptions, and the political chicanery in the architecture of government, far from deserving any kind of a castigation for their what you call courageous reporting. This was the what you call understanding with which the judges is spoken in this particular decision. My dear friends, the New York Times, the Washington Post, and other newspapers should be commended for serving the purpose that the founding fathers saw so what you call critically. In demonstrating the workings of the government, in revealing the governmental transactions that lead to the Vietnam War, it has been realized, my dear friends, that newspapers nobly did precisely that which the founders, or founding fathers, expected and trusted they would do. My dear friends, this kind of a ruling is not possible in South Asia. That is the point which I wanted to bring. This was the point which I wanted to derive home. And that is why, my dear friends, in the context of United States of America, if we find this kind of a ruling, my dear friends, and this kind of a ruling, possible for New York Times and the Washington Post to publish the so-called Pentagon Papers in the journalistic language, but the real name, the official name that was given to Pentagon Papers was the report of what we call of Office of the Secretary of Defense Vietnam Task Force. Without any kind of risk, government censorship or punishment. It has been ordained, it has been reduced into black and white in this particular decision. New York Times company versus what we call United States decision of 1971. It was written in the judgment, my dear friends. There cannot be any kind of a governmental censorship. There cannot be any kind of a chastisement on the part of the government of the United States of America for publishing. Try to contextualize this kind of a decision that was delivered way back in the year 1971 in the current what we call scenario, how the state power is what we call chasing another important journalist. I'm talking of the chief of WikiLeaks, Julius Assange, whose extradition is still pending before the Honorable Supreme Court of the United States, United Kingdom, UK's Supreme Court. And there are demonstrations on daily basis in favor of Julius Assange and against extradition of the Julius Assange from Britain to United States of America. If you take into account, my dear friends, the ruling that was delivered in this particular decision, then the conviction, the trial of the Julius Assange is likely to violate some of the important norms which have been handed down in this particular, decisions delivered by the Federal Supreme Court of United States of America. Because on the basis of the arguments handed down in the US Supreme Court ruling, two dimensions regarding the fundamental relationship between democracy and freedom of the media will be of vital importance. And it is this particular ruling has opened a new kind of debate between power and deception. Because we should not forget, in the context of South Asia, my dear friends, that the central principle of democracy should be recalled. And what is that? Democracy is merely an open system in which politics should be understood as an everlasting problem solving process by guaranteeing a deliberative, what you call, conclusion. A conclusion at the same time which also takes into account the participation of as many individuals as possible. Do you think this is possible, or it has become possible, or it is possible in the current, what you call, scenario in South Asia? Therefore, it must be adumbrated, my dear friends, that democracy is a political system. The purpose of democracy is to hinder the establishment of the permanent power structures so that its problem solving capacity can be sustained. However, if you take into account democratic competition alone, which keeps the, what we call, systems open, it is not sufficient. Because the democratic competition in the form of the party struggle is ultimately just a struggle for power. And every struggle for power, my dear friends, tends in the end to be exclusive by trying to exclude others from power. So that is the situation which has been, what you call, depicted in this kind of a scenario. Only through strict regulation and limitation of the struggle for power, along with the plurality of opportunities for participation, can the system be kept open and ultimately pragmatic, result oriented, and effective. This is precisely the reason why freedom of speech and expression, my dear friends, is so important to democracy. Freedom of speech fulfills, my dear friends, dual functions. Functions of a vital, what we call, importance, and that serves the idea of what we call of, constitutionalism. Because constitutionalism constitutes one of the most important, what we call, facet of a functioning, what we call, democracy. It is the deliberative problem solving mechanism that empowered the political system by simultaneously controlling the same power. At the same time, my dear friends, another institution that fulfills a similar vital function in a democracy is the judiciary, especially the constitutional courts. Democratic political process is basically an institutionalized, what we call, conflict. To establish an institutionalized and ritualized conflict as the prevalent mode of democratic politics, the conditions and rules of a continuous, violent, free political sphere must be set in a peaceful manner. But that remains a distant dream in the context of what we call of South Asia. If a independent journalism is publishing, if an independent, what we call, journalist is critical of a governmental policy within the four walls of rule of law, democracy, and human rights and constitutionalism in South Asia, then he is branded as anti-national. That has created a lot of problems, because a democratic constitution, my dear friends, establishes merely a dispute and violent free zone within everyday politics. It can be effective only through interpretation, since what should be considered dispute free in a democratic system cannot be determined in every detail through a mere reading of the text. And that is why this responsibility lies with the judicial establishment in each and every geopolitical entity, including South Asian jurisdictions. And such kind of a liberty, my dear friends, a dispute-free, what we call, space, must thus be redefined repeatedly according to the specific situation or case at hand. Therefore, democratic principle of participation in a democracy is merged with the constitutional principle. And since majorities, my dear friends, use in South Asia their dominant power, either in their own interest or to maintain power, a strong compensatory power limiting the majority power, therefore is required. My dear friends, constitutional courts are bearers of a compensatory common welfare responsibility. When we are talking of the functions, the powers, the role of the constitutional courts, then the constitutional courts embody, my dear friends, Montesquieu's dictum that power can be limited only by power. And therefore, constitutional courts represent somewhat the answer to the centuries old question: who will guard, who will protect, who will what you call guard the guardians. It is no accident that in their struggle to maintain power, authoritarian and totalitarian regimes pursue two basic what you call goals: the limiting freedom of speech and taking control over its constitutional courts. If we leave aside developments occurring in nation states beyond what we call European nation states like China, Russia, India, Pakistan, Bangladesh, and concentrate on Europe and its what we call neighbors, it becomes evident that the current problems related to freedom of speech and independent what we call media cannot be deliberated without placing them in the wider context of authoritarianism, and especially what we call populism, with which all the South Asian jurisdictions have been suffering from. Therefore, in general, limitation of freedom of speech should be understood in relation to multiple developments in state and society in South Asia today that are tending towards the successive establishments of or establishment or dispensation of the authoritarian regimes, which seek basically to regain national control over global what we call developments. And this is what we have been particularly witnessing in the context of Islamic Emirate of Afghanistan. As illusionary, my dear friends, we find it prima facie speaking, as this aspiration may be, it should nevertheless be admitted that the what we call the status of the freedom of press or the communication rights in Afghanistan emerged from the Talibanized what we call dictate, and that is fundamentally anti what we call media freedom, and this should also be taken into consideration. Is there anybody from Afghanistan in this class? Now, I have a question. If you are willing, you can contribute. And the question is, why, my dear friends, why press freedom should be at the top of individual agenda, collective agenda, governmental agenda? Why? Why should we attribute the highest what we call regard to the majesty of the media freedom? Can you answer this question? What is your take? You are connected online. I simply ask you, look around the space, look around the room, look around the hall, whatever room you are in. How many people, my dear friends, do you see? Supposing you are counting correctly, everyone in the room will come up with the same what you call number, and that number is a fact. We can share it, and we can also form opinions on the basis of our what you call counting. Therefore, my dear friends, by invoking this kind of an example, I can say that each and every opinion, each and every what we call, navigation of view is important, but it may also, differ. The opinions which are expressed individually and collectively may differ, but the facts do not. Unless, of course, you are among the growing number of governments that restrict the free press or free expression of facts they don't like, or declare that everyone is entitled to their own facts. And down that path, my dear friends, lies the demise of the responsible journalism and the degradation of the freedom and democracy. And it is unfortunately the path we are on in South Asia. We have been witnessing a lot of violence against journalists. And I will come to that also, my dear friends. And we will try to understand what is the meaning of the safety of journalists, what are the dimensions of violence against journalists, what is the importance of independence of journalism that we have to take into account. Because the concept of media freedom constitutes a very, very important discussion. And it is, deeply rooted in both the political science and the mass communication literature, including law. For example, my dear friends, listed freedoms of associations, information, and communications as essential components of democracy. This reminds me of two important, thinkers, Gunther and Mugan. They have called mass media the connective tissues of democracy. Another important, authority who rightly pointed out, I think, in the late 90s, my dear friends, so almost more than 25 years ago, and who had rightly written that without the freedom of communication, mass media provide the foundation of democratic rules is undermined. If you take into account the assessment of the early definitions of the free press or the press freedom, these definitions, my dear friends, focus primarily on freedom from government control. And in their classic work, my dear friends, the four theories of the press, another important what we call, experts, Peterson, Siebert, identified four models or theoretical types of media. And the first, historically speaking, was the authoritarian type, where the government controlled the press through prior what we call censorship and through punishment after publication. They labeled a more current variant of the authoritarian model, and that is the its while Soviet communist what we call model. The liberation or the libertarian, I should say, a model was seen as the counterpoint to the authoritarian model. The primary feature is the absence of the government control. And the fourth model, my dear friend, the social responsibility model, and that holds the media have obligations to society and that accompany their freedom. There is another important authority on this particular point, and that is the Lowenstein, who rightly pointed out, I think in 1970, that a completely free press is one in which newspapers, periodicals, magazines, news agencies, books, radio and television have absolute independence and critical ability except for minimal libel and obscenity laws. The press has no concentrated ownership, no hegemonistic what we call corporate authority, rather the marginal economic unit or organized what we call self-regulation. And this is something so far the self-regulation is concerned, we have been witnessing in current what we call scenario, because many of the news channels, my dear friends, in current what we call circumstances, have created their own institutions of ombudsman, where they are entertaining some of the important what we call facets of regulation, self-regulation. Another important authority, my dear friends, in 1975 or 77, I am talking of Viva, who distinguished the three components of the press freedom: the relative absence of the government restraints on the media, the relative absence of the non-governmental restraints, and the existence of the conditions to ensure the dissemination of the diversity of ideas and the opinions to the large audiences. Another important authority with the equal what we call stature, Picard, in 1985 rightly what we call argued and distinguished between negative press freedom, the absence of the legal controls such as the censorship, and the positive what we call press freedom, the ability of the individuals to use the media. Therefore, my dear friends, we can say some have argued that the definitions of the media freedom should include other concepts, such as the role of media in nation building, economic development, overcoming illiteracy and poverty, and building political consciousness. Therefore, media, what we call democratization, is vital, and that has also what we call proposed altering the top-down one-way flow of messages from contemporary mass media to the public by increasing citizens what we call participation. And therefore press freedom, one type of freedom of communication, others were freedom of speech, freedom of opinion, and information freedom. So these are the different what we call dimensions when we are talking of this kind of a concept. But before I proceed further, it is equally important, my dear friends, when we are talking of free media in South Asia, with its international counterparts in terms of scholarship, in terms of literature, in terms of conceptions, in terms of what you call of the conceptualization. According to Macaulay, he opined in the year 2000 regarding the concept of media freedom. Macaulay was of the view that the concept of media freedom includes both the degree of freedom enjoyed by the media and the degree of freedom and access of citizens to media content. The essential norm is that media should have certain independence sufficient to protect a free and open public expression of ideas and information. But the second part of the issue raises the question of diversity. Diversity, my dear friends, as a norm that opposes concentration of ownership and the monopoly of control, whether on the part of the state or the private media industries. This is the, that has created the fundamental problem. And that is why the entire what we call, debates has been what we call, rendered or sandwiched between negative rights and positive rights. It has further what we call, or rather I should say, this entire debate has also been further what we call, quibbed by the emergence of what we call of, of international law, particularly international human rights law. In international human rights systems, my dear friends, such as the Council of Europe, media pluralism is the corollary of a media freedom. This is because Liberal democracies have learned from history that powerful media institutions, whilst they must be autonomous from the state, also have the potential to destroy democracy because they can exert a powerful influence on public opinion. When media concentration enables public opinion to be shifted and controlled by powerful media gatekeepers, the democratic process loses, my dear friends, its legitimacy. And you have to contextualize my argument in the context of South Asia. And this is why media freedom is accompanied in all mature democracies by structural controls on ownership, mergers, and control of media companies that are well reflected and embedded in international legal standards. These are delivered through competition and company law, but have specific objectives different from the normal objectives of the competition law, namely the protection of democratic deliberation and the prevention of concentration of power. Therefore, it is important that we must have some kind of a media pluralism in South Asia. When I say media pluralism, my dear friends, I am talking of the media diversity, as it is called in United States of America as well. The principle that the concentration of media markets should be limited and that democracy is served by a plurality of the media outlets, content types, and the view democracy is served by a plurality of the media pluralism. It forms part of the European Union Charter on Fundamental Rights and the Federal Communication Commission. And this commission has also drafted certain rules in the United States of America. It is implemented in antitrust and merger rules in media sector and can also be conceived of in terms of what we call of autonomy. But when I am talking of autonomy, it means the necessity of avoiding a situation in which large media players, and I can give you an example of the Murdoch empire, who is controlling Z News, and who has been so dominant that he can obtain power over government actors. Of course, none of these laws and frameworks are perfect, but there is a long history in liberal democracy of trying to use them to draw a line and to protect media freedom. My dear friends, media freedom and media pluralism are also direct corollaries in the sense that a reduction of the media plurality would justify less media freedom in order to check power. Because with power comes responsibility. But who is discharging this responsibility? It's $1 million question. And it has become some kind of unfettered power in South Asia without any kind of accountability or without any kind of transparency. The notion of media pluralism, therefore, is a core principle of the media freedom. Who is free and to what extent they are free? It is exclusively determined by considerations including their power over public opinion and the public resources they might use or they generally use. The principle is simple, my dear friends. Those media institutions that are most powerful should be subject according to a sliding what we call a scale, which is grounded on their size and dominance, to more checks and balances of that very power and the guarantees of the responsibility. If News International or the BBC or indeed Facebook decide to promote an issue or suppress a viewpoint, this matters a great deal more than if a humble blogger does so. Ultimately, it is the principle of size and power rather than public or private that should govern decisions about whether private actors or public authorities should be considered censors or editors, regulators or speakers. This is why, my dear friends, competition and other regulatory issues are so closely linked, and why policies such as the European DSA and the online safety bill, which is currently in the debate right now, and there are a lot of writings in public domain regarding this particular bill in United Kingdom that has also set out thresholds of contentions, thresholds, and graded approach, tougher restrictions apply to larger, more influential what we call platforms. So that remains to be answered. My dear friends, the question of which structural rules and design principles need to be applied in a democracy, must be posed afresh as new internet intermediaries, such as the social and search what you call companies, take on the role of the mediating intermediaries in the new media system, displacing the companies, particularly of what you call services. We have currently realized, and this is particularly important because the new internet media differ in major ways to the old media, and particularly in their ability to tailor and target media content to the interest and needs and vulnerabilities of the particular what you call audience and other important sections even of individuals. This poses the problem of propaganda. Propaganda in the sense or the extent to which media are able to shape public opinion in a new setting in which the doctrines and also the precise rules, thresholds, levels, and measures to protect media diversity and pluralism, and that need to be revised in the current what we call South Asian scenario. It may be the case that even a company that controls a small part of overall media market in South Asia can have a damaging what you call effect on the process of what you call of deliberations and discussions and the legitimacy of what you call of the various state transactions like holding elections. If it controls enough personal data to target messages effectively, to swing a constituency and to choose to do so, core regulatory codes of the conduct should set out a framework of voluntary self-restraint so that new media commit to refrain from propaganda. This process has already started, for example, with the self-imposed limits on political advertising being considered by Twitter, Facebook, and other important platforms, because there have been what you call lot of influence of Freedom House, what you call kind of organizations, Transparency International, what you call kind of organizations, or Human Rights Watch kind of what you call of organizations which have been what you call influencing the working and functioning of these kind of media or social media platforms, and it is in tandem what you have Mr. Sagar Verma has pointed out in your what you call term paper. So it is very very important how you have been, I mean, approaching these particular issues, because without particularly in the context of South Asia, we cannot ensure freedom of media without ensuring the idea of the non-conformity. Non-conformity is of vital importance, and it is the idea or the element of the non-conformity which ensures the pluralism or media pluralism or plurality of media platforms. And this is manifest in the widespread social concerns about filter bubbles and targeted propaganda, which can dub surveillance what you call democracy. And this is has become rampant in the context of South Asia, that the Pegasus kind of what we call of softwares are in use in some of the jurisdictions of South Asia and beyond what we call South Asia. And from the point of view of the media freedom, my dear friend, this shift is important because it heightens the requirement for limits and conditions to be placed on media power, and also changes the nature of those limitations and what we call conditions, because media freedom or freedom of expression is cited as a reason to reject algorithmic accountability or artificial intelligence, what we call ethics, that is of vital importance. For example, in relation to the imposition of transparency requirements or qualifications of liability exemptions under the Digital Millennium Copyright Act or the e-commerce what we call directives in Europe, and this will and should increasingly be seen as a concern for what we call human autonomy within the context of what we call of the control by non-human agents, and not merely as a concern for expressive rights or the communication rights and the abstract value of the liberty of the media that ensures what we call. And under all circumstances, we can say that South Asian media or the media freedom in South Asia is not at all free from the technological developments which are taking place in the other what we call parts or in the global north jurisdictions, because the developments which are taking place in the global north jurisdictions are equally influencing, impacting, and they are also having some kind of a transnational impact on our part of what you call of rights, and whatever the rights have been promised. So I will definitely deliberate the further what you call aspects of the dangers as well as the dangers of what you call of your rights in negativity, rights in positivity. On the next occasion I will continue. So thank you very much for the day. If you have questions you can ask, and please complete your cycle of submissions of your term paper in the area of international media law. Those some of the uh, midterm papers I have, I mean, end term papers I have, already received, but many more people are there who have to submit their what you call, term papers. So thank you very much for the day. Enjoy yourself. Thanks a lot for being with me. Bye bye. Take care. If you have questions, you're most welcome. Please, you can ask questions, no issues.
Sir,
Sir, I have. Go ahead, Maharaj. Go ahead.
Yeah.
why media freedom is should be very important? I mean, you posed a question before few minutes.
Ooh.
Freedom of speech and expression is very important.
Yeah.
That it includes, as we also in the last classes discussed, right to import, receive, and it this free speech also rooted in the philosophical writings of John Milton, uh, Stuart Mill on liberty, chapter 2. So um, along with life and liberty and equality, this speech and expression has been given wide connotation and interpretation by the Honorable Supreme Court of India and High Courts in India. And
Yes.
media freedom is very indispensable for the democracy. That
Agreed.
it in Kushbu versus Kanyamal case, where she made some remarks and affairs was charged against her. So in that context, the court held that or observed that uh, democracy cannot function without free and open discussion. That we should tolerate unpopular views. That
Yes.
culture of open dialogue we should
Yeah.
promote. And in Observer Guardian versus UK, where the UK context was the uh, yeah, in the court held that this media has freedom to express. At the same time, it is also a to duty on the part of media to inform the citizenry. And
Mm.
where the court held that this freedom is not only this right to receive is not only the materials which are inoffensive, but it also includes the information which offend and shock. This there also a book called free speech, Gautam Patia,
Yes.
written by Gautam Patia. And when we are saying these freedoms, there are limitations to that. In ICCPR and Article 19 Class 2 we can find, and even in Article 10 of European Convention on Human Rights and Article 13 of African Charter. And
Yeah.
but when it comes to UD
On the
Gacha, I
same
do not
lines, you
find
have
any.
written your term paper.
Yes, sir.
Mr. Maharajan, you have the same thing you have written in your term paper.
Yes, sir.
In the night, I was, going through your term paper. You have beautifully written. And it is very, very important. You have rightly pointed out that it is basically the non-conformity argument to diversity and pluralism that should also be the basis of a democratic freedom in the context of media freedom. But if you take into account the current scenario of freedom, where we have been witnessing the rapid technological change, modernizing media systems, And these systems might require new forms of accountability and regulation of media and media freedom. But at the same time, we should not forget, my dear friends, the new interventions. These new interventions have been seen as conflicting with the media freedom as it has been ordained in the schematization of the 8 constitutions of the Saarc nation states. Because whatever the legal doctrines, such as the content neutrality, for example, if you can take a case in point, and as per this, what you call, doctrine of the content neutrality, the state should not interfere in speech in ways that discriminate among sources or forms of what you call content, for fear that state actors will abuse their power to shape opinion in their favor. This is the beauty, and this should be the beauty of the news diversity. Independent and safe, accountable, transparent media freedom in South Asia. And that has become the biggest casualty in the current what we call scenario. And you have rightly pointed out, even in your term paper, that it is the beauty, at least non-conventional points, opposing views, alternative views, optional views must also form the basic, or particularly in public domain. And that is why the media houses are favoring some kind of a self regulation, but the self regulation is not working, and we should try to locate the effectiveness, or rather I should say the primacy, within the legal framework of self regulation. This may be the what we call another important topic for your term paper writing, for your research paper writing. This particular research, this particular gap should also be identified. Yes, you can conclude your observations. I have intervened just to enrich your line of argument. Yeah, please.
So media assumed an important role in this era, 21st century, and so it is, as rightly you in the fourth week argued, it emerged as the fourth state organ of the state. Therefore this sensitivity, TRB, and profit oriented should be there, but it should be up to a level. But this in the last class we also discussed this media ethics. So ethics, neutrality, independence, transparency, the which we also should keep in mind. So uh, there is a place we can discuss everything, but it is for the people to decide. So we offer a platform, media as a thing which offers a platform to discuss. So it is the people of any country to decide. So, and yeah, that's.
Yeah, thank you very much, brother. Any other observation, input from anybody?
Yes, sir.
Yeah, please, Mr.
Sir, to actually, there are first observation I would like to supplement to Maharajan's argument, where he said that profitability. He used the word profitability. So there was as you pointed out in this lecture, that the involvement of the big media houses, that was my question in the previous class also. But my thought was that if profitability has to be managed, how it can be managed by a small, I am not saying that a small media house is not a media house, or for that matter a individual cannot be the source of information. The point is how it can be managed with the word profitability, because uh, I have also pointed out in my term paper about the big conglomerates like Twitter, or social media platform owners who have so much of wealth that they can buy in one night the entire platform. So, uh, how it can be controlled? That is my first question. And second question is, as far as the traditional or contemporary media is concerned, there is a one-way communication. So it was possible to authenticate, or it was possible to have a mechanism where you can put reasonable restrictions based on the freedom of speech and expression. But when there is two-way communication, like in case of social media, it is extremely difficult to understand the difference between a content creator and a journalist, because a journalist will have his sources authenticated, will have his cross examination, will have his sources validated. But as far as content creation from the perspective of a social media user is concerned, uh, he has, as you have rightly pointed out, and I agreed to it, that it is based on the propaganda, or it is based on the things that are being propagated in the social media. So how these things can be balanced? uh, yeah.
Yeah. Any observation, Mr. Maharajan, in response to Mr. Sagar Verma's contention?
No, sir.
Yeah. Anybody else? Mr. Talha, would you like to offer something?
So I have written my term paper. Just now I will go to send. In this paper, I have expressed my opinion about the three-part test, which is very important on the, I mean, in regard to the put the restriction on freedom of expression, conscience, and also press and media. So this three part of test is most important. But it is great sorrow that most of the South Asian country, they did not follow this test. This is my opinion
Well,
about.
please allow me to study what you have written and what has been your pervading line of argument in your term paper. I will definitely, because this gives me a very very important opportunity to try to identify my contentions mentally and try to understand your bent of mind while going through your term papers. Anyway, so thank you very much. And Mr. Sagar Verma, please do not forget what you have stated just now. So I am taking your leave and I will respond. I will begin my what we call, responses in the next class with your contentions. You have rightly pointed out, you have always been there to enrich our ongoing deliberations. So thank you very much for the day. I take your leave to leave. So, and I will get back to you on this, and I will begin my submissions with your inputs. Thank you very much.
Thank you, sir.
Yeah, thank you. Thank you very much. Bye bye. Take care.